You can put us on the record.
Already?
Hello, Your Honor.
Good morning. Okay, looks like we have audio connection with everyone. This is a matter of Rogers versus Rogers, Airway Welding Company. Mr. Spiegel and Mr. Inocencio are present. I granted Mr. Spiegel's request for an emergency hearing. But before I hear any arguments, Mr. Spiegel, is it true that you refuse to accept email communications from Mr. Inocencio's office?
Absolutely not. I've been receiving communications regularly all the time. My fax machine works all the time. I have no problem receiving communications from Bruce. I have a great fax machine, and he sends me hundreds of pages of faxes all the time.
All right. Well, from this point forward, there will be no fax communications. All communications will be by email, including copies of all pleadings. I can't order you to do exchange of pleadings solely by email. You can only stipulate to that, but I can certainly order you to do it by email in addition to what the court rule files. Fax machines are obsolete, Mr. Spiegel. There will be no more fax communications in this case. You will receive, both parties will receive whatever is sent via email, and you will respond timely to whatever you receive. Is that clear?
It is absolutely clear, Your Honor, and I will abide by your request and ruling.
Certainly.
So, Mr. Inocencio, did you see the latest order proposed by Mr. Spiegel? And if so, do you have any objection to me entering it as he proposed?
Your Honor, here's my issue. So not to dodge your question. So I have seen the order, okay? But what I don't understand is why we are revising an order.
I understand that, Mr. Inocencio. I fully get that you don't appreciate that we're getting peppered with yet additional orders, but that wasn't my question.
I understand that, Your Honor.
I'm not asking you whether or not you agree with the procedure by which we've arrived at that order. My question is just very simple. Does this order adequately address the issue of the exchange of information by the respective accountants of the parties?
I think that I cannot refute what is included in the order. My concern is this, not even so much as the procedural aspects, okay? At this point, since we were last before the court, we now know that we have approval from the lender to move forward. And actually the lender is able to close the deal tomorrow. So I don't know why we would even be wasting time providing these documents. So not to bypass the process here, but we have SBA approval. There's no need to wait until December 18th. The agreement was that the closing would occur no later than December 18th. My clients are able to close tomorrow, and so is the lender. So I don't know why we're going through the process of wasting time and money paying accountants to share information that does not need to be shared at this point.
Mr. Spiegel, do you agree that everybody's ready to close tomorrow and we don't need another order?
I have no closing documents. I have no signed agreements. I have no exhibits. I have no information as to the Schedule Ks. In fact, the entity that is listed on a draft agreement, which is totally incorrect, is Airway. It should be Doug Rogers. I want this matter to go forward. I will do everything I can to prevent it from going off the rails. My 2 letters sum up the problem. I was so pleased. I can't tell you how happy I was that Eric Friedman and Harold Grossbart are on the same page. They know exactly what needs to be done. I think they can do it. Once we get the numbers, we can figure out what else needs to be done. In the meantime, I can get deeds, I can get documents, I can work with Mr. Innocencio in revising the few documents that he sent to me. I can then get them to my client. My clients happen to be out of town. I establish what I think is a reasonable time frame. We can get this done if we all work together and get it off your docket. That's what I want. And it's going to, as Your Honor knows, we've gone through this in the past, 10 years ago. And if everybody works together, we can get it done. It's not as complicated as Bruce thinks it is. The documents need to be revised. They can be revised. They will be fair, just, and equitable. But it's going to need some cooperation. It's going to need some help from Eric, from Harold, from me, from Bruce. And if Bruce wants to get another lawyer to help him with the transactional documents, fine. I don't care. I want to get this thing done, but I want it done correctly. Correctly is very important.
May I respond, Your Honor?
You may.
I don't understand why the statement is being made that I can get someone else to help me. We have proposed agreements in Mr. Spiegel's hands. We do not need someone else or another firm to come in and provide the transaction documents. We've presented those. The issue, as I understand it, from Mr. Spiegel's letter, is that he is instructing his clients not to sign what I have sent him. And the only reason that he's saying that's appropriate is because the agreement that we have is between his clients as individuals and my clients as individuals. Is that correct?
That is incorrect, Mr. Innocencio.
Oh,
Let me
please.
give you 3 examples. Your document requires representations and warranties that are impossible to give. Your document contains a indemnification, which can't be given. Your documents don't address the real estate. Your documents don't address the profit sharing plan. Your document requests a certificate separate from an assignment separate from certificate without a legend. You cannot do that simply because you would be violating MUSA, Michigan Uniform Securities Act, and the Securities Act of 1933 as amended, because it is going to have a legend indicating it is a private placement subject to SEC Rule 144. So, and that is the same. We need to get the documents correct, Bruce.
Well,
let's work together and get them correct.
Your Honor, if I may respond. I have not heard any of what you just said from you in a letter or an email or a fax or anything other than the issue of the issue that you raised a few minutes ago relative to the parties being incorrect. And I'd like to address that briefly, if I may, Your Honor. There's no doubt that Michigan contract law, this is contract law 101 in Michigan, documents are freely assignable. And in reliance on the stock redemption agreement, in this case, which applies, my clients as individuals have assigned their rights in the settlement to Airway and Brit, which they are fully and legally entitled to do. And they've done that. And that's how the transaction will move forward. I don't understand why the claim is being made we have the wrong parties. We don't have the wrong parties. The lenders have approved it as such. The stock is being redeemed through the company, through Airway. The shares are being redeemed through Brit. That's totally appropriate. It's legal. My clients have assigned their rights to do that. And the lender, the SBA, is on board. So why, and this does not impact anything on your client's side. And in fact, Judge, if I may, I spoke with Harold Grossbart on Friday. Very clearly asked him this one question. Do any of these documents that are being requested have any impact at all on the transaction? And his answer was no. None of this matters. at all. There's no reason to provide this. When we talk about the K-1s will be prepared at year end. Regardless if we want to argue about this or not, there's nothing that can be refuted to suggest Mr. Spiegel's clients will not be employees of these entities in any capacity on 12/31 of 20. The K-1s will be prepared by the accountant for Airway and Brit going forward in reliance on the documents. And we are allowed to do the allocation. There's never been a dispute about that. So I don't know why would we need to see check ledgers and any of this stuff? It's creating more work and time wasted and money spent. And all of this stuff for reasons, I have no idea why we're doing this. I just don't understand. The accountants say they don't need it. I guess let's, you know what we should do? We should call Eric Friedman right now and let's add him to the call. And you know what he's going to tell us? The accountant for Joe Spiegel's clients? None of this is going to change it. None of this will change anything.
That is incorrect. If you want to have an evidentiary hearing, that's fine. Let me give a bottom line, Your Honor.
I don't want to do that.
If we don't go through this process, there will be no settlement, and Mr. Inocencio can file a complaint and attempt to have this settlement enforced. We will request that my clients go back to work pursuant to the preliminary injunction, and that'll be the end of it. It's that simple. I have never seen such pushback, errors in corporate law, errors in transactional documents in my life. With all due respect, Your Honor, I'm trying to keep this on board. What I've proposed is reasonable and rational. Eric Friedman specifically said, and Harold agreed, they're going to need possibly a short year K-1. We don't know what that's going to say. It may be more or maybe less. It may have an effect on the purchase price. It may not have an effect on the purchase price. Mr. Inocencio, from day one, has pushed against providing transparency. And I got to tell you, Your Honor, I want this deal to close, but I'm not going to let my clients sign one piece of paper unless I'm satisfied, Eric's satisfied, that they are fair, just, and accurate. So,
Your Honor,
Mr. Inocencio wants to file a lawsuit. Go ahead. Be my guest. I'm trying to keep this on board.
Your Honor, I'm not
pushing back. I have been begging for documents for 2 months.
And we have been waiting for
I have been begging for documents. And, look, Bruce.
All right. I don't want to hear. I've heard enough. I've heard enough. I'm going to sign Mr. Spiegel's proposed order with the following additional language. The parties' attorneys shall exchange all communications, documents, and pleadings via email and not by facsimile. No further correspondence may be forwarded to the court except as exhibits to properly filed papers with the court. And I'm going to tell you what else I'm going to do. If this deal falls apart, I'm likely to appoint a special master. The parties will share responsibility for that special master. The special master will be someone who has expertise in corporate matters to report on me whether either one of you has been incorrect in your respective assertions as to what is or isn't required in terms of documentation for a deal of this nature. The person I have in mind is my former partner, Clyde Malden, whose opinion I value very highly. And if I find, based on whatever he reports, that either one of you has been unreasonable or obstreperous, there's a good chance I'm going to award some kind of sanctions. I'm signing that order now. I don't want to hear any more from either one of you. Thank you.